audio or video is not allowed in this courtroom. Anyone found to have any audio or visual recording of these proceedings can face subject to fine and or dismissal of your case. Calling to calendar, small claims number 990-25, Terrell Taylor versus Michael GIAMMELLA.
Counsel for defendant, please state your appearance for the record.
My name is Maria Taylor, the Commissioners of the State Insurance Fund, on behalf of Michael GIAMMELLA.
Mr. Terrell, would you please raise your hand? Do you solemnly swear or affirm the testimony you should give tonight will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please state your name, followed by your address for the record.
Terrell Taylor, 174-22, 125th Avenue, Jamaica, New York, 11434.
Thank you both.
Good morning.
Morning.
So, Mr. Taylor, this is your case. Just by record, I do see there was a recent decision on a motion that was filed by the defendant from Judge Goldman, denying the defendant's motion based on the fact that all of the papers were not received. Is that correct, counsel?
That is correct. I do have a copy of the motion with me today. It was filed in its entirety on November 25th. I'm not sure what happened, where only the notice was received, but I do have the entire motion with me today.
Okay, but Judge Goldman has already rendered a decision. Is your office refiling the motion because he did deny it without prejudice?
I can refile it today. I have a copy.
All right. Before we move to that, Mr. Taylor, this is your case. What is this case about?
There was a non-appearance on December 10th, 2025. Can we talk about that, please?
There was a non-appearance.
About a defendant, yeah. The default.
Okay, I just have here, it was adjourned to today.
You have anything regarding what took place December 10th, 2025?
No.
So, how am I supposed,
Well, there was a motion. It seemed to have been a motion that was on, and it was.
there was a non-appearance on December 10th,
You just asked me a question. I just answered your question. All I have is that there was a motion, and then it was adjourned to today. So from December 10th, I have the adjournment date as being today. So what is your position? That it was a non-appearance by the defendant on December 10th?
Yeah, that's why this notice right here, it says the adjournment was for a control date.
Right.
And then it got switched to for all purposes after this decision by Michael H. Goldman. So I went to inquest. I went to the inquest part on December 10th, but I was told to come back to this room right here, 305, and it just got adjourned, and it was adjourned for a control date. So my argument is, should there be an inquest hearing or something before you?
Well, it wouldn't be an inquest hearing because the defendant is here. So only time it's marked for inquest, right, is when the party is not here. So they are present. So if you went over next door to the JHO for inquest, it technically would not be an inquest because the defendant is here. So they're here.
So what is going to be done about the non-appearance, the default on December 10th, 2025? Just going to forget about that?
Well, I don't know what you mean if we're going to forget about it. It was marked, and then there was a motion that was submitted, and then it was adjourned for today. So I'm not sure what you would like me to do. If you want to file a motion, you can, to present your position. But I don't know what you would like me to do because now we're March 18th.
Do you understand what I'm saying? Do you understand?
I understand what you're saying. I wasn't present on December 10th.
Okay.
It appears as though on December 10th, I do see it was sent to inquest and then it was adjourned to today. I wasn't there. So I don't have any additional notes to tell you what parties or whomever was present at that date meant, but here we are, March 18th, and I can't send you to in-class because the defendant is here.
Okay, we can move forward, but
Okay.
it's so crazy. Like if I miss like one opposition or anything, anything I miss, a deadline or something, it's a big issue. You know, the defendant don't appear, something in the past, I just forget about it. You know, you don't do anything about it, it's just forgotten about. But let's just move forward. Or whatever we're gonna do.
Okay.
I'm ready for trial today.
Are you ready for trial?
I'm ready, but before we move forward on the merits, I just wanted to address a jurisdictional argument. The civil court is not the proper jurisdiction for this case.
Okay. And Mr. Taylor, what's your position on the jurisdictional argument?
Jurisdiction? What is the argument again? This ain't the proper court?
Defendant, can you please repeat so that Mr. Taylor can hear what your position is?
It's frivolous. It's baseless. You know that. That's baseless. But what does the defendant say? Please say it
I
again.
can go into more detail, Your Honor. Okay, so this is not the proper jurisdiction because based on the summary of complaint or the statement of claim, the primary reason for this is failure to pay an insurance claim. NICES is the workers' compensation provider, and at all relevant times, the defendant, Michael GIAMMELLA, was acting in his official capacity as a NICES employee. Claims for money damages against the state agencies such as NICES are properly handled in the Court of Claims, and that's according to Court of Claims Act, Article 9, subsection 2. In addition to that, the underlying claim is for a workers' compensation, and any workers' compensation claim must be litigated before the Workers' Compensation Board. That's Workers' Compensation Law, section 20, 23, and 123.
Thank you.
Nonsense. So was there a motion filed for that reason? And was this?
Yes. There
So-
was a motion filed for that reason. For some reason, the entire motion was not uploaded, which then rendered why Judge Goldman issued the decision denying it without prejudice, advising that they needed to have the complete motion. So, that's their position. So if you wanna go to trial, they can bring forth the same argument at the time of trial.
Yeah, let's go to trial because I oppose that argument. You know, I have my opposition here, but I mean my reply. I'm pretty sure it's addressing that if that's what was in the motion papers. So I already responded to that, but we can move forward.
You have your reply.
Our office did not receive any replies.
What reply do you have? Do you mind showing me, Mr. Taylor?
For my clarity, it seems to address that the defendant argues that the claim should be dismissed as jurisdictionally improper, though it's my understanding that the court never received the motion documents. Is that
Right,
correct?
we didn't.
You on 23?
Yeah.
23? What do you got?
I've read the reply and the argument.
You want to say
It's still jurisdictional improper.
Okay. So you're ready to move forward, Mr. Taylor?
Yes.
I will move forward.
Okay.
All right, Mr. Taylor, it's your case and your burden.
Oh, make my argument, you mean?
Yeah.
What is this?
Okay.
What is this? A bench trial?
Yeah.
Okay.
This is a small claim. According to your statement of claim, you presented a claim for failure to pay insurance claim in the amount of of $10,000, so it is your burden.
Okay, so first and foremost, the defendant Michael GIAMMELLA, that's my insurance adjuster. That's the guy who cuts my check for my workers' compensation claim case, and this is why he's being brought to court. He works for NYSIF, but he's my adjuster. He works for New York State Insurance Firm. I'm allowed to bring him to court just like I bring anybody else to court. You just put their name down as a defendant and bring them to court. I don't have to put NYSIF. I don't have to put New York's Department of Workers' Compensation Board. Michael GIAMMELLA, that's my insurance adjuster. That's why I'm suing him. Now, there was a decision by the Workers' Compensation Board. It was an amended decision. It's dated, what is this dated? The date of filing of this decision is March 25th, 2025, and it's ordering the employer or the insurance carrier to pay me $275 per week. And here's a copy of that decision right here. You want to see it?
Okay.
It's from the Workers' Compensation Board.
Okay.
There was an email prior to that of the of Michael GIAMMELLA letting me know that he intends to file a RFA2. That's a form requesting the Workers' Compensation Board to reduce my disability rate and my compensation payments to $275. So here's the email where the defendant is clearly telling me that, you know, they intend to reduce my benefits to $275. So here's the email.
Okay. So you gonna show it to her? Yep. I'll see it.
So we have the request being made by the defendant. Then following that, this is on January. This request, this email making me aware that the defendant is going to file a request is January of 2025, and then this decision, like I stated, is in March of 2025. So then there's an email with me asking the defendant, do they plan on sending my compensation payments, you know, as a result of this amended decision? And the defendant is responding, stating that they are appealing the amended decision, so my payments are suspended. You can't appeal a decision by the Workers' Compensation Board, and even if you were to appeal a decision by the Workers' Compensation Board that was made, it doesn't stop the payments. I'm injured.
You have authority? I mean, okay, so you made that position or argument. What is your authority with regard to that position?
What's my authority? What do you say that again?
What is your authority to the basis of that workers' compensation decisions cannot be appealed? Like where are you getting that from?
Oh, I don't need authority. This is a work-related injury to my lower back. The Workers' Compensation Board has the final say-so on everything. So,
Let's get to the crux of the claim. So the claim, as against Mr. GIAMMELLA in his capacity as his official capacity as the insurance adjuster to your claim. Anything else you have? What else do you have?
yeah, this is the email I'm showing you where you didn't look at this yet. So this is just, like I said, I'm asking Michael, why is he not sending out the compensation payments? and he's stating, the defendant, he's stating that he's appealing the decision, and the payments is suspended for that reason. So here's that email, and that's about it. Those are the 3 documents that shows that I'm owed payments from 3/25/2025 up until today. The defendant made a request for a reduction. It was granted, or whatever you want to call it, and then the defendant doesn't follow the order. That don't even make any sense. And then you like, I don't.
Okay. Is that all the evidence that you have, Mr. Taylor?
That's it.
Do you have any witnesses that you wish to call, Mr. Taylor?
Nah, witnesses.
Defendant.
I would like to just again reserve that the court is not the proper jurisdiction due to a lack of subject matter jurisdiction, but to get to the merits of the case, the 3/25/2025 Workers' Compensation Board decision references at the bottom of page 2, Workers' Compensation Law 25(3)(f). There is third department authority concerning 25(3)(f), which says, quote, that 25(3)(f) of the Workers' Compensation Law makes clear that an application for board review for a modification, decision, or review of such award operates as a statutory stay of payment during pendency of the board's review. Pursuant to 25(3)(f), NYSEF, not Michael Giammella was acting within his official capacity as a case manager for NYSEF at all times. NYSEF filed an application for board review on or about April 14th, 2025, and very recently, on February 18th, 2026, the board rendered a decision on appeal, stating in due part that the amended decision filed on March 25th, 2025 is modified to direct that NYSEF is not to continue payments. I have a copy of all 3 for your review.
Thank you.
What is this again?
It's March 25th, 2025, notice of decision, NYSEF's appeal, and then the February 18th, 2026 decision of the board on NYSEF's appeal.
What is the argument here?
The argument is that pursuant to Workers' Compensation Law 25(3)(f), it was proper for NYSEF to discontinue payments until the board rendered a decision on its appeal, which it did so on February 18th, 2026. In that decision, it said that the March 25th, 2025 notice decision was amended to say that NYSEF is not to continue payments. So that portion where it says that we will be continuing payments at $250 was removed, basically.
That law that you're talking, can you just say, hold on, I just want to write that down.
It's also on the second page of the March 25th, 2025 decision. And I can give the case law over.
It's on this too as well? You said, where is it?
It's not on that one, it's on the other one, March 25th, 2025. That's February 18th.
Is it the one that you just gave me here?
No, it's on the other one, to give you the
Oh, I'm sorry. This right here.
So at the bottom of that page, right there, 25(3)(f, that paragraph, right?
Okay.
The one you
I
pointed.
see it. I just need something. Can I have it? Can I just write this down real quick? All right, thank you. Okay,
I just want to see what the amendment is. All right, so,
I guess I will look all of this up whenever I get the chance, but it wouldn't make no sense you know, that I'm suffering from a work-related injury, right? And then the board agrees to a certain amount per week, and then the defendant is allowed to appeal that while I'm in the middle of an injury. You know, to me that makes no sense, and that's my argument here. You know, it wouldn't make sense for the and I didn't know I was going to trial today, so I'm not even prepared for this. You know,
Well, I'm sorry, Mr. Taylor, I asked you what you wanted to do.
No.
You said on the record, when you finished, you said that you were ready for trial, so that is what we did.
But
So what I'm not going to entertain is for you to say that you were not ready, because you specifically said that you were ready.
no, that's cool. I am ready. Could we take a quick recess to look that up? Because this is not. This is. All right. Well, yeah, that's my argument, because I'm not allowed to look up this workers' compensation law to see if that argument is valid. But you know, like I said, if you're in the middle of a work-related injury and a decision is rendered by the workers' compensation board, you know, it would make no sense for the payments to stop in the middle of an injury because the adjuster feels like that don't make any sense.
I do also just want to add that plaintiff does have recourse according to Workers' Compensation Law 23, and appeals can be taken to the third department. In addition to that, he had 30 days to appeal from the February 18th, 2026 decision from the board that was rendered about last month.
Oh, okay. So the 30th day is coming up like tomorrow.
Yes. So he does have to exhaust his administrative remedies before going forward in a project.
With the remedies that are available through workers' compensation.
That is correct, Your Honor.
Okay. Anything else?
Outside of the jurisdictional arguments and the workers' compensation law arguments, no, I rest.
Okay. Anything else, Mr. Taylor?
That's about it.
Okay. Thank you very much, and I'll render the decision shortly.